So the next case is State of Ohio versus, I don't have my name,
Ghouche.
Ghouche. Okay. Anyway, so the state is not going to be arguing, so you'll have 15 minutes to present your arguments.
Can't reserve 3 minutes to argue against myself.
Hey, I do that all the time with myself, so could be interesting. All right, you may proceed.
Thank you, Your Honor. Joseph Patituce on behalf of Mr. Ghouche. The last two assignments of error is where I wanted to start, because it might seem at first that assignments 4 and 5 were kind of the cursory, here's manifest weight and sufficiency, but this is a refusal of OVI offense. And as this court knows, and it is common practice in a refusal case, field sobriety tests are typically not admissible. They're not evidence of impairment of any form. From the 19CA manual itself, the 3 standardized field sobriety tests do not carry any level of whether or not a person is physically impaired or unable to drive a vehicle safely. It's merely a predictor as to whether or not somebody would be over the legal limit. So when we look at the evidence that was admitted at trial, the relevant evidence was odor of alcohol, speed, the officer believing the defendant was traveling in the wrong direction. So I believe when we look at the sufficiency for what was submitted, it fell woefully short, especially when we watch the video and you get to see the defendant's performance on the 3 field sobriety tests, which I would like to jump to now. The trial court below had a curious ruling that the defense failed to raise or put the state on enough notice to be a traditional motion to suppress. And I believe the reason for that is that the trial court below has a new local rule that says if it's not raised in the front page of the motion, it's not to be considered. And I think that's the actual local rule which this court can take judicial notice of. Because when we look at the face of the motion, it does challenge the field sobriety test. The court stopped there, because when you go into the actual brief, the defense, the original trial team, did raise with specific instances of error by the officer. And I believe when you look at the local rule, that explains why the trial court ruled that this was just a blanket challenge. On the multiple pages in the memorandum that was attached, starting at page 2, going through page 7, and on page 8, the defense cites 2 particular sections of the manual. They cite just particular issues, and I think I believe that's what happened here. There's no ruling from the court that says that's why the court ruled this way, but the court clearly ruled that based on the 12th district's decision that the state of Ohio only had to prove slight compliance, not full substantial compliance. In other words, the court ruled that because there was not enough notice here, they just needed to show generally it was okay. Because when we look at the video, though, we show that these field sobriety tests were not performed in substantial compliance. Starting first with the horizontal gaze nystagmus test, the largest error between moving the defendant to sitting on a cruiser was the use of the black glove. The manual requires not that the person has to be able to see the stimulus with perfect clarity, but the manual clearly lays out that it has to be a contrasting image. And here, the unchallenged, undisputed testimony was that it was a black glove against a black background at night, and that the flashlight was not illuminating his finger. So there was no contrasting stimulus for the person to be able to track the stimulus, which is required of the horizontal gaze nystagmus test. You have to be able to see that contrasting image. As we move into the other 2 tests, the walk and turn test and the one-leg stand, I do believe that when we look at the testimony of the officer as well as the dash cam video, and the 4 photographs that were submitted, I know that the trial court did not find the 4 photos to be of evidentiary weight, but when we look at the photos compared to the video, this was on an incline. It was on gravel. It was an incline that the officer made multiple comments about it being an incline, about, yeah, this is a little steep. This isn't a situation where it's a reasonably flat surface free of debris, which is what the manual requires for, and it makes sense for a test where you're going to take 9 steps in each direction and then stand on one leg for up to 30 seconds. So when we look at that in and of itself is problematic when we're talking about substantial compliance, because for the 9th District precedent, substantial compliance isn't just good enough, it's performing the test with just minor errors, minor deviations from what the standard requires, and here we have major errors. It's almost, for the two physical tests, as if the test started off at a disadvantage to the defendant, the appellant here, because it's an angle, it's on gravel, it's everything else that goes into it, two cars passing, but when we watch the video, and I know that it's a de novo review as it goes to the law, and an abuse of discretion it goes to facts, the video was supplemented into the record for the court to review. I would submit to the court this is one of the better dash cam videos that the court would review. This is not an individual who has slurred speech of any form. This is not an individual who in any sense of the word appears to be impaired, which then goes to the reasonable suspicion to remove the defendant from the vehicle. I know I'm kind of going backwards and I apologize. Bloodshot glossy eyes is one of the factors that the trial court relied upon in finding that there was a reasonable suspicion to remove the defendant from the vehicle. Bloodshot eyes, and the testimony bears this out, the manual bears this out, bloodshot eyes has not been a clue of impairment according to NHTSA for over a decade. Since 2007, bloodshot eyes has been affirmatively removed from clues that troopers or officers are to require or to evaluate in determining whether or not somebody is under the influence of alcohol. There are a number of reasons why bloodshot eyes can exist outside of alcohol impairment, and that is straight out of the manual itself, and I think most officers agree to that, though it's still, in some districts, it still is used as it's still used, because there is an abundance of case law that talks about that. I would be dishonest if I said it wasn't.
Oh, I was gonna say, I could probably list off 10 right now.
Right.
But in those cases, there's also usually the bloodshot eyes coupled with the odor of alcohol.
And slurred speech. I think that's when we look at a 2255, that administrative license form, I think it almost always says in order, bloodshot eyes, odor of alcohol, slurred speech, and then it talks about a failed sobriety test or some form of traffic infraction. Here, the odor of alcohol, oddly, the trooper, I apologize, the officer never described the strength of that odor, whether it was coming from the defendant himself or it was coming from the car. And I think what is better for the appellant is when the defendant was moved from the car, there was never a further description of whether or not the alcohol was still coming from this person. So it could have been alcohol that had been spilled in the car, it could have been somebody who was in the car prior, but there was never a description that the alcohol was actually coming from the appellant's breath. There was an odor of alcohol of some degree with no reference to the severity or the strength of that alcohol, that odor coming from the car. There was a purported speed violation, coupled with the odor of alcohol, no slurred speech. The insurance...
Counsel, regarding the speech, there is some indication in the state's brief that he was difficult to understand.
I did notice that, Your Honor, but when I go to the transcript, and I apologize for not having that readily memorized, the officer agreed his speech was not slurred.
Okay.
And that, we did cite that in our brief, and it's clear as day on the video. There's no difficulty, no difficulty hearing the speech. His speech is not in any way slurred. No one would think that this individual was speaking with a thick tongue or he might have been nervous. He sounded nervous. I get nervous when I've been pulled over for speeding. But then as far as the operation of the vehicle, he was speeding, the officer turned around right behind him, and I know it was described as a wide turn was the description by the officer when he testified, but he later agreed the wide turn is not on camera. You actually see the whole stop, the entire process. It's a normal stop. He conceded on cross-examination. It's a fairly safe stop. And what that implies is that the person operating the car is operating not under a level of impairment, but under a level of awareness, because it's not a wide turn that goes over a double yellow line. It's not a turn that the person's just not really paying attention. It's a deliberate, direct pulling off to the side of the road. And I believe the officer agreed that where the defendant stopped was actually safer than where it was when the lights first came on. So that fact tells me, or I think it tells a finder of fact, that this person may not be impaired. Maybe they were just speeding. Maybe they were lost. I, not living in Medina, have gotten lost multiple times coming to this courthouse. So those are the factors that we have. We have speed, which the officer agrees is not an indicator of impairment, but it's certainly sufficient to stop the vehicle. There's no argument that you can't stop somebody from speeding. The stop of the vehicle in phase 1 of the NHTSA manual was done properly and safely. There was an issue with the insurance, but it wasn't that he wasn't able to get his insurance card out of his glove box or out of his wallet, the standard divided attention. It was, and I guess this is becoming more common, but he had the insurance card on his phone, and for some reason the app simply wasn't working. I don't know that an app on a phone not working is reason to believe somebody's committing a crime, especially drunk driving. I mean, there's no testimony whether it was a signal issue, whether he's roaming, whether it was the app simply wasn't working.
And obviously the other side has indicated it was a password issue, that he couldn't remember his password.
Right, but I think when you watch the video, again, the video contradicts much of what the state raises in their brief. And it is very important to watch that video because you can hear the interaction. And Mr. Ghouche does sound, again, incredibly nervous, which I think is a normal interaction with when you've been pulled over by law enforcement. But again, I believe the main issue you have here is that the trial court below applied an incorrect standard. The trial court did not evaluate this under the weight it would normally be given, or the proper standard when a defendant has properly raised in a motion to suppress the substantial compliance with all 3 of the standardized field sobriety tests. And I believe that we did cite that in our brief. We have that on page 12 of our brief where we begin our discussion of that. The trial court said that the state only needs to show slight compliance. And the trial court cites to a 12th district case which predated Guadalupe. Guadalupe has shifted us into just a mere notice pleading that we're challenging the field sobriety test, but the defense below did more than that. The defense actually talked about the 3 standardized field sobriety tests. So certainly the state wasn't ambushed. There was no trial surprise here or anything like that.
Counsel, so that I am correctly understanding the argument, is the argument A, that because of the motion, that the state only had to show slight evidence of substantial compliance, or is it B, that they had to show clear and convincing evidence of slight compliance? What's the...
My main argument first is that the trial court applied the incorrect standard. It relieved the state of Ohio of its burden of showing by clear and convincing evidence compliance with 4511.19D, substantial compliance.
Okay, but go ahead.
Because the court ruled that the state only needed to show slight compliance. That was we look at the trial court's ruling, and the trial court did issue a decision, I believe on page, I'm going to use my time to...
It's okay. I'm looking at it right now.
Okay. So my first argument is the trial court erred by using that lower standard. My second argument, though, is that even if I have been wrong before, I've been known to be wrong, even if I am incorrect on that standard, if we look at the traditional review, whether the state actually satisfied that clear and convincing standard, my argument is that they failed based upon the dash cam video itself. The dash cam video, which we moved into evidence, shows that there was no substantial compliance. So my first argument is the trial court erred in the standard, which I think is correct. But if I am wrong, my second argument is that if we actually evaluate it fully, that the state still failed to meet the proper standard. I believe the proper remedy here would be to send this back for a full motion hearing on the motion to suppress, ask that the trial court apply the full standard and proceed from there. I do not believe that, I think that's the proper remedy here. I don't believe that the proper remedy is to fully vacate the entire proceedings, dismiss, and enter not guilty and dismiss the case. I believe sending this back for the proper standard on the motion to suppress is the proper outcome.
Any more questions? Thank you, counsel.
Thank you, Your Honors.
Thank you. We'll take the matter under advisement and issue a written opinion that will be sent to both sides, and we also will release on our website. So thank you.